I'm Brandon Paiva, a lead advocate with Chisholm Chisholm Kilpatrick, the nation's largest and most experienced veterans law firm.
Hi, I'm Robert Chisholm, a founding partner of Chisholm Chisholm Kilpatrick, and today we wanted to share some exciting news with you about a major victory that CCK had before the Court of Appeals for Veterans Claims regarding TDIU, or total disability based upon individual unemployability. Brandon, tell us about this case and what it means for people with TDIU claims at the agency.
Absolutely. So our colleague, attorney April Donahauer, recently argued Witkowski v. Collins before the U.S. Court of Appeals for Veterans Claims. This case specifically challenged a long-standing VA process that created what we would sort of coin as unnecessary delay for veterans who are unable to work because of their service-connected disabilities. We've been working for over 10 years to find a resolution, and we finally have it.
So tell us about that process and how it has now changed as a result of Witkowski being decided by the court.
Absolutely. For decades, VA used a two-step regulatory process when a veteran's combined disability rating was below a certain level, but the evidence showed that the veteran could not maintain employment because of their service-connected disabilities. This is commonly known as Extraschedular TDIU, otherwise known as 4.16b. Under this process, the Board of Veterans' Appeals was required to first send the case to the Director of Compensation for review before the board could even make its own decision on this matter. Now, this procedure came from a case called Bowling v. Principi, and while it may have seemed harmless in theory, in practice, this actually caused some serious problems. Typically, veterans would often wait years for their claims to move forward because of this process.
So they had to remand, that is, the board had to remand the case to the Director of Compensation, which is at the agency level. And many times, if not most times, the director would deny those claims, and then the veteran would have to get back in line at the board to get the case reviewed. So instead of doing it the first time, it would delay the case anywhere from 3 to 5 to 7 years. And that's not good for veterans, right?
No, almost stuck in this endless loop. So in Witkowski, CCK Law argued that this extra step was actually not required by law, and that the board itself should have the authority to decide whether a veteran qualifies for TDIU without having to go to the director first. Therefore, trying to avoid this sort of endless loop process of the veteran's case going from the board back to the agency level and back and forth as many times as it takes to render a final decision.
So we now have a ruling. Tell us what happened.
This case was unusual in that the government actually agreed with us that the two-step process should not apply. But we did disagree on how the court should make that change. Specifically, we debated whether a 3-judge panel or a full court panel, what's known as en banc, should issue the ruling. After the case was heard en banc, we were not really certain how the decision would come down. But on October 21st, the court issued its opinion, and it was a huge victory. The court overturned Bowling, ending more than 20 years of procedural delay that had previously hurt countless veterans who were seeking TDIU on this what's called extraschedular basis.
So this is a real victory for veterans, because now when a veteran meets these qualifications and they go to the board can decide the case straight up without remanding it back to the Director of Compensation, resulting in faster decision. So I've got a sort of strategic question that I'd like to ask you. Would you rather take a case for TDIU to the rating board at the regional office and have the Director of Compensation decide it? Or, practically speaking, do you think it might be better to go straight up to the Board of Veterans Appeals and have the board decide the case now?
Straight to the Board of Veterans Appeals. Typically, we've seen more favorable decisions and overall better decisions from the Board of Veterans Appeals from a perspective of being just overall more well-reasoned and overall really accounting for the veterans' disabilities on a case-by-case basis. We typically haven't seen a lot of success coming from opinions rendered by the Director of Compensation. So, in our opinion, I think we'd much rather see these decisions come from the Board of Veterans Appeals.
Thanks, Brandon. And I agree 100% with what you just said. At CCK Law, we are proud to have repeatedly played a role in bringing about changes like this through litigation and court advocacy before the Court of Appeals for Veterans Claims. And as you noted, this was a decade-long fight where we brought multiple cases and finally got the one correctly positioned for this outcome. We will continue to fight to make the system better and more efficient for veterans. You can learn more about our precedent-setting cases at cck-law.com or on our YouTube channels. Thank you and take care.